All right, let's try this again. Hello, everyone, and welcome to Uncivil Law, the channel where we learn from others, the mistakes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's story, we're doing some IP law. It's right, intellectual property law for us today in Nike versus Lil Nas X. So Nike makes shoes, and Lil Nas makes songs. And now Lil Nas also wants to make shoes. And Nike is displeased. They would like to sue Lil Nas for a whole bunch of things related to intellectual property law, which is good, because I'm an intellectual property law lawyer. That means that this is my area of expertise. How fun. So we get to comment on this, and we get to try to figure out what Nike is complaining about, and we get to try to figure out what the likelihood of them succeeding and their likelihood of success and all that great crap is. So let's do that. Let's get started with this. All right, great. So this is in the United States District Court, Eastern District of New York. We are, of course, in federal law, Nike versus MSCHF Production Studios. And this is a complaint for trademark law, false designation of origin, which is trademark law, trademark dilution, which is trademark law, and common law trademark, which is trademark law. So yeah, we're doing 4 counts of trademark. Trademark infringement, delusion, trademark, false designation, trademark, trademark is trademark. Great, it's all trademark. Great, we can comment on that intelligently. Let's talk about this. All right. So MSCHF is currently taking orders for shoes it refers to as Satan shoes, which are customized Nike Air Max 97 shoes that MSCHF has materially altered to prominently feature a satanic theme. This is done without Nike's approval or authorization, no joke. And Nike in no way is connected with the project. Yeah. Below is an image of a genuine Nike Air Max 92 shoe next to MSCHF's customized Satan shoe. The material alterations include at least referring to the shoe as the Satan shoe, adding red ink and human blood, which apparently there's actually a drop of human blood into the midsole for some reason, adding red embroidered satanic theme detailing, and adding a bronze pexagram to laces, and adding a new lock signer. So we see the two competing shoes, the two shoes. So we have the genuine Nike Air Max shoe 97 on the left and the unauthorized Satan shoe on the right. So we can see that these two shoes look very similar in their design, but of course there are some fairly material differences. For example, the gel part of the shoe on the Nike Air Max is clear. On the Satan shoe, it is red. And we see some red stitching that has apparently been embroidered onto the shoe. And we see a pentagram that I'm not exactly sure what that is. Either some sort of embroiderment, or it's some sort of trinket or something maybe put onto the shoe. Okay, super duper. And of course, they're the same design and all the rest. And they still both have the Nike check marks. Okay, so the first thing that comes to mind here and is going to be of some note in this issue, at least potentially, is if these shoes are modified versions of Nikes or if they're made custom. So are these like made from the ground up to look the same as Nike shoes with these details, or rather have the people who have made these shoes taken off-the-shelf versions that anyone could buy and made customizations to them? And that makes a material difference, or at least could make a huge material difference when it comes to trademark law. Because if you make a product from scratch that looks the same, uses the same design elements, uses the same logos, right, then that's probably almost certainly trademark infringement. So if you make the same looking shoe from scratch, trademark infringement. However, if you are using an off-the-shelf shoe and you are merely altering it to make these changes, then the trademark claim looks a little bit more shaky. There's an idea of a first sale doctrine that at least kind of applies a little bit. And there's also an idea of people being able to make customizations to things without it being a problem. I mean, this happens in the car industry all the time. There are companies whose mission in life it is to take cars and modify them. I can give you at least one example off the top of my head. There's a company called Singer. and Singer takes off the dealer Porsches, and they modify the shit out of them, and they call them Singers. But they were a Porsche to start with, and now they're a Singer. But they still look like a Porsche, and they still mostly are a Porsche, but they're not called Porsches anymore. They're called Singers. So that might be one example where this manifests. So it might make, and probably does make, a pretty substantial difference in the legal interpretation where these shoes are coming from. So we'll press on. Nike has not and does not approve of the MSSCHF customized stadium shoes. Nor do they necessarily need to, because if you modify your own stuff, right? Moreover, MSCHF and unauthorized stadium shoes are likely to cause confusion and dilution and create erroneous association between MSCHF's products and Nike. In fact, there's already evidence of significant confusion and dilution occurring in the marketplace, including calls to boycott Nike in response to the launch of MSCHF stadium shoes based on the mistaken belief that Nike has authorized or approved the project. All right, so when we're talking about this kind of stuff, one of the things that we can consider is the relative sophistication of the consumer at hand. Because the more sophisticated the consumer is, right, the harder it would be to, like, deceive them, right? So if this is just an average, normal retail product that anyone can go and buy, right, that's one thing. But if it's a more sophisticated product, then a person who is spending money or is in a position who is spending a lot of money or is buying a sophisticated product is more likely to not be confused about what product is what and what's not. Now, we are not looking for the lowest common denominator here. We are not looking for find me a person who was confused, right? We're looking for a more material likelihood of confusion. You know, you can always find one idiot. There's probably someone somewhere who is buying a Singer and thinks it's a Porsche, even though they're spending like twice as much as a Porsche is because of the amount of modifications. But the fact that a person is stupid, even a rich person is stupid, is not going to do the trick, right? We're looking to consumer confusion in the relevant marketplace. So the question is, how likely a relevant consumer would be. Now, these shoes in question that are being offered by MSCHF are over $1,000. That's an expensive shoe. So again, for shoes, it's expensive, right? It's everything is in context, right? So it's expensive for shoes. That's the relevant marketplace, right? So one would imagine that the person who's spending $1,000 on shoes, who knows that shoes are not normally that expensive, might know that something's up, right? So they might be a more sophisticated consumer. And that especially is true of the people who are likely to buy these Nike shoes, because I would think, and this is just off the cuff opinion, right? But I would think that the type of person who's likely to buy Nike shoes of these kinds are more familiar with the Nike brand. I would think that a person who's buying these customized shoes from this customized website is more likely to be familiar with Nike. There are a lot of Nike heads out there. There are a lot of people who know Nikes with disturbing levels of detail. So in the grand scheme of, is it more likely to be a consumer who just happens to be passing by? Or is it more likely to be a consumer who has some knowledge and some information and some sophistication with respect to Nikes? It strikes me off the top of my head that it's more likely to be in the sophisticated camp. So I will take their word for it that there's some idiot somewhere who thinks that this is being sponsored by Nike. But some idiot somewhere is not necessarily the standard we're looking for. We're looking for confusion by the consumer. That's the ultimate thing we're concerned about, right? The ultimate point of trademark law is to protect the consumer. The fundamental point of trademark law is to make sure the consumer isn't being misled. So you have a feeling or an understanding concerning Nikes in general. You like Nikes, you don't like Nikes. And so if Nike makes a product and you like Nikes already, you're more likely to like the product because you like Nikes. And if Nike makes products, you're less likely to like the product because you don't like Nikes. And this is basically the same for every product ever. It's like making sure the consumer knows what they're buying and is not tricked in the consumption of their buying. And that is our fundamental consideration from trademark law. So as long as the consumer is not confused, it's probably going to be fine. So we have to calculate the relative likelihood that the consumer who's in this particular market would be confused by thinking that these do come from Nike or authorized by Nike. So I think that's the dominant consideration we need to look at this from. Nike files this lawsuit to maintain control of its brand, to protect its intellectual property, and clear the confusion and dilution in the marketplace by setting the record straight. Nike has not and does not approve of the shoes. As an innovative brand that strives to push the envelope and do the right thing, Nike knows it may not please everyone all the time, which, is pretty much true of every business ever, especially a lesson I have learned more palpably as of late, because when I try to please everyone, it just winds up making me miserable. But decisions about what products to put this swoosh on belong to Nike, not to third parties like MSCHF. Yeah, that's fair, but who put the swoosh on, right? That's going to my original thing of, is this built from the ground up, or is this merely a modified shoe? Nike requests the court immediately and permanently stop them from filling orders for the unauthorized shoes. Okay. All right. Nike is a corporation organized under the laws of Oregon with a principal place of business in Oregon. So they are a company that their principal place of business and their place of incorporation are the same. A little bit unusual, but there you go. It's Oregon. Great. Upon information and belief, MSCHF is a Delaware corporation with its principal place of business in New York. This action arises from trademark law, so we can skip all that, right? We're federal question jurisdiction, so that makes it super, super easy. Okay, great. Nike's principal business activities, the design, development, and worldwide marketing and sales of athletic footwear, apparel, equipment, accessories, and services. Nike is the largest seller of athletic footwear and apparel in the world. We'll take their word for it. Nike sells its products directly to consumers through Nike-owned retail stores and digital platforms, and to retail accounts, and a mix of independent distributors, licensees, sale representatives in virtually all countries of the world. Nike uses its trademark on nearly all of its products. Having distinctive trademarks that are readily identifiable is an important factor in the market for Nike in identifying its brand and distinguishing the products from others. That's basically 100% true, right? That's the point of trademark. We want trademark to be distinctive, to help you identify the source, to distinguish this source from other sources, so the consumer knows what they're buying. That's kind of the point. As a result of continuous and long-standing promotion, substantial sales, and consumer recognition, Nike's developed powerful trademark rights, including the marks described in the complaint. I don't think anyone can dispute that Nike has powerful rights. If Nike is going to argue that they're a famous mark, by the way, I believe them, right? Famous mark has a particular meaning in trademark law. Basically, it's companies of such great prominence that they are known throughout the land in cross industry. I think Nike qualifies as a famous mark. So they therefore should have intellectual property protection in every domain. Nike maintains strict quality control standards for its products bearing its trademark. Genuine Nike products bearing the Nike marks are inspected and approved by Nike. Okay, I believe you. Nike maintains strict control over the use of its trademarks. That I believe for sure in connection with its products, so company can maintain control over its reputation and goodwill. Nike, for example, carefully determines how products bearing its trademarks are released, when the products are released, where the products are released, and how the products are released. Yeah, I mean, of course they do, right? They're making a product, and they want to determine when the product is good enough, whatever that means in Nike's subjective judgment, because it's their product, right? They want to determine when the product is good enough to bear the Nike swoosh and the Nike name. And they want to determine when, where, and how to sell them because it's their stuff. Not particularly controversial, right? Among Nike's most iconic assets are the Nike wordmark and the swoosh. The U.S. Court of Appeals for Ninth Circuit has referred to the swoosh as a famous trademark. I agree. Yeah, I don't even have to read the case to agree. This is a famous mark, has a special meaning in trademark law, right? So yeah, it basically is for companies of, global, universal, cross industry renown Nike qualifies, no problem. Nike identified the word mark and the swoosh in 1971, and since then has continuously promoted and sold its products bearing the name. Sure. Nike has also promoted and sold products bearing Nike word mark. Nike sold billions of products with these marks. Nike spent tens of billions of dollars in promoting its mark. Nike advertised its products bearing the mark through a variety of mediums. As a result of these efforts for 50 years, it's become famous. I'm there. The Nike word mark and swoosh have received unsolicited publicity and praise from consumers. For example, in 1993, the Nike swoosh was ranked number 1 on Complex's magazine top 50 most iconic brand logos. I think that, whether or not they're number 1 or not, they're certainly in the running for iconic, sure. In addition, Nike word mark and swoosh mark have received judicial and administrative recognition as famous, recognizable, and valuable. Yeah. Nike has the registered mark Nike on the principal register of the trademark. Of course they do. Here's a whole bunch of marks we have. Pursuant to the relevant law, Nike's United States trademark registrations are incontestable. They've definitely passed the contestability period long ago and constitute conclusive evidence of validity. I don't think anyone is going to dispute that Nike owns their marks. Yeah. Nike's also registered on the principal register for a wide range of goods. So here's our swooshes and stuff. Yeah, they've got a whole bunch of that too. They're incontestable. No problem, I believe you. Great. So we got Nike covered. All right, I believe all those things. All right, how about MSCHF? On March the 22nd of 2021, a Twitter account, this was 8 days ago? So Nike's acting relatively quickly. They probably sent a cease and desist notice first and, it didn't work. A Twitter account focused on sweet sneakers and popular culture published the following tweet announcing the Satan shoes. MSCHF and Lil Nas X Satan shoes. Nike Air Max 97 contains 60cc ink and 1 drop of human blood. 666 pairs, individually numbers, $1,018, March 29th, which would be today. If I would think that a person who's going to drop $1,000 for shoes would be less likely to be confused that this was an authorized Nike project, but that's just immediate off-the-cuff speculation by me. Following publication of the tweet, numerous media outlets reported on the satanic theme of the shoes, and then MSCHF will be releasing a limited edition of 666 individualized numbered Satan shoes. The Satan shoes are scheduled for release on March 29th, and I'm assuming they're no longer available because they probably sold out. On information and belief, MSCHF uses the website satan.shoes/project to promote its Satan shoes. On the website, the body of the Satan shoe is a Nike Air Max 97. Which it is. It is the body of that. The website further says each shoe contains 60cc of ink and 1 drop of human blood. Why? Is human blood really the way to go here? If you're doing this, wouldn't goat blood be more appropriate for a Satan shoe? I don't know. What do you guys think? You think human blood is the way to go here, or is goat blood more on point? They went with human blood. According to media reports, the red drop of literal human blood is incorporated into the sole of the shoe. Making change to the midsole may pose safety risks for consumers. I guess. According to the website Snopes.com, a representative of MSCHF told Snopes in email that, okay, this is going to be critical details here, right? MSCHF buys the shoes from Nike, then MSCHF artists make their own creative modifications. So that is an important detail that we now have that covered, right? These did start their life as genuine Nike shoes. And they are making changes to the shoe. They have bought the shoe, right? They have bought the shoe. So you buy a product, you're able to make modifications to it, right? You can do whatever the hell you want with it. It's your shoe, right? And if you want to resell the shoe, you can do that, right? You can't deceive people in the sale. So you can't represent that they are genuine Nike shoes, but probably people can figure that out on their own, but you want to make them clear in some way that they're modified or altered So, to avoid that, but, your ability to resell your own property, right? So they bought the shoes. It became their property. They made modifications to their own property. They now want to resell their property. And so the only real question becomes whether or not the consumer is misled, whether or not the consumer is deceived, whether or not the consumer thinks or could reasonably think, the reasonable consumer, not the lowest denominator consumer, the reasonable consumer could think that this is an authorized Nike project. How many of these people who bought these shoes thought that this was a Nike thing at some point? And depending on where this case goes, right, the Nike could theoretically, they could theoretically depose all 666 people of them, because I know it's not an incredibly long list, and Nike is a big company. It's not like they can't depose 666 people if they really want to. So, we could actually not even do a survey. We can do a census, right? We could literally ask every single person who bought whether they at any point thought this was an authorized Nike collab. That could be fun, depending how deep we want to get into this. So we're going to figure out whether or not we're going to dispose of this on a dismissal motion or not. We're not that far along yet, but if we get that far, we'll see. Indeed, the pictures of the customized Satan shoe on the webpage reproduced below show numerous significant alterations from genuine shoes, which might be, in and of itself, the very reason this complaint won't work, right? If they are numerous and significant alterations and not subtle or low, that is more suggestive that a person in this market would perceive that they are altered, right? If they are numerous and significant, it would increase the probability that an ordinary consumer looking at this would know that they are altered Nike shoes, which kind of goes in M's favor. I'm not going to keep trying to do their name. It's impossible. We'll just call them M. And we got some more look at the Satan shoes with the Satan insoles, with the star, with Satan, and CH. Is that Champ? Satan Champ? With the little pentagram tag and the rear thing with the look, and it says MNASH on the back of the shoe. One might think, for example, that might reveal to the consumer that this is not exactly a Nike shoe. The fact that this other brand is prominently put on the shoe would be suggestive against. For example, the side of the shoe features red embroidery that states Luke 10:18. The New International Version of the Bible states the following. He replied, I saw Satan fall from lightning from heaven. So it's a verse dealing with the fall of Satan. Also embroidered in red on the side of the shoe is number 6 and out of 666. The number 6 and 666 are commonly associated with Satan. Yeah. A circular pendant with a pentagram is attached to the lace. A pentagram also appears inside the heel. The pentagram is also commonly associated with satanic imagery. Further, at the tab at the top of the tongue of the shoe shows a red inverted cross. In popular culture and film, the inverted cross is also associated with satanic and demonic activity. Yeah, that's not really completely fair, because isn't the inverted cross, I'm trying to remember, this is outside my knowledge, but isn't it like the sign of St. Peter or something in Catholicism or something like that? Hold on. Yeah, it's the cross of St. Peter. I was exactly right. Booyah. My knowledge is great. Yeah. So yeah, in the inverted cross is actually a symbol of Christianity. It's the symbol of St. Peter. So, it's kind of that too. So yeah. It's nice to know these things, right? As seen from the back of the view of the shoe, the left shoe depicts the letters MSCHF, which is sort of a clue that it's coming not from Nike, and the right shoe depicts the letters Lil Nas X, which is also kind of a clue that it might not be coming from Nike. The air bladder of the sole sole appears to be filled with a red liquid. A genuine Nike Air Max 97 does not contain any of these features. Right. Which is, again, why the consumer in this circumstance, I don't know for sure, but my guess is the ordinary consumer in this market who's spending $1,000 on shoes probably knows something about the Nike Air Max 97 and probably knows this is not what the Nike Air Max 97 looks like. Despite the drastic alterations, again, seems to suggest against, right? When we're talking drastic, that increases the likelihood the relevant consumer will not be fooled. The same shoes still prominently display the Nike swoosh logo, which is the only sort of counterindication. But then again, the swoosh logo was there in the first place. So I guess we could remove the swoosh logo, right? We could unembroider it or cover it up or something. It would be like the most logical thing. But that's the only real thing Nike has going for them, is it still displays the swoosh. So maybe the remedy here is to remove the swoosh. And anyone who knows anything will know it's still the Nike Air Max, but it won't have the swoosh. So if there's a confusion because it has the swoosh, right, the remedy would be like, how about we just remove the swoosh before we do anything? So, assuming that's the problem, the remedy seems pretty easy. In a short time since the announcement, Nike has suffered significant harm to goodwill, including among consumers who believe that Nike is endorsing this statement. Again, this is not necessarily a least common denominator issue. And this is also an issue of what we might call the difference between perspective confusion and actual confusion, right? So some of these people might be idiots, but the real level of confusion, the top mark level of confusion, is if a person who bought the shoes or has RSVP'd the shoes or whatever, has put down some sort of money or something, thought that it was a genuine Nike product. If one of those people thought it was a genuine Nike product, that would be super helpful. And even then, we are not doing a least common denominator problem, but it would be helpful. But rando idiots, is not really, Anonymous. Oh yeah, we're quoting a person who literally calls himself anonymous. That's great. Never buying a Nike shoe, bunch of hypocrites. Crazy they need Jesus. I don't know what either that means. This is terrible. Won't buy again. You are banned. How do you know these are responsive? How do you know these are responsive to the shoe? Incidentally, you're not making it clear how you know that. You're just citing random comments, and you're not providing a context that reveals to me that these comments were made in some way. You're just saying that these are examples of consumer commentary. You're not saying these are examples of consumer commentary in a discussion regarding the shoes, or these are comments we've got into our helpline regarding the shoes. You're just saying these are random comments. So how do you know never buying Nike shoes again, bunch of hypocrites, they need Jesus? How do you know that's responsive to the shoe? Or more to the point, how's the court supposed to know that? How's the court supposed to know that's responsive to the shoe? Maybe they think that you need Jesus because of your sweatshops. I don't know. Maybe that's the reason. Who can say? You're not giving me enough context. This is terrible. Won't buy Nike again. You're banned. For what reason? No more Nike for anyone in the family. For what reason? I'm appalled. Words cannot describe the amount of disgust and disbelief. This is truly happening. Jesus, please save us. Never supporting or buying Nike again. Responding to what? I will never wear another pair of Nike. I'm throwing all the ones away I have now. What a disgrace. This is pure evil. What is pure evil? What is pure evil? How do you know that these comments are responding to the shoe? More to the point, how's the court supposed to know these are responsive to the shoe? Do you want to say why you think that? Are these somehow in some context? It's clear. If it is, it would be helpful to know what that context is. Otherwise, are you just assuming they're responsive to the shoe? What makes you think these comments are responsive to the shoe? How are you coming to this conclusion, Nike? Nike will no longer have anyone purchasing anything else from them. Tell the righteous people in the back, said, thank you for allowing us to see who you are. They always sold us a lost to push sick narrative. What narrative? This is sickening. How's Nike not involved when there's a Nike symbol on the shoe? Which shoe are you referring to? This could not be a scripture on Steph Curry sneakers, but the count for this, F Nike. This is disgusting. Nike should be canceled for this. Canceled for what? Guess no Nike for me. Why? Of course Nike's collaborating or they'd be threatening to sue. Well, they're doing that. You cannot say there's no agenda being pushed here that could not make evidence. I'm done with Nike. Okay. So, all right. Look, I'm not saying that a reasonable person couldn't believe that these comments are responding to the shoe, right? There's a question of fact to be had there. So if it ever gets that far, a jury might be asked to decide whether or not these comments were made responsive to the shoe. And perhaps after testimony or whatever, the jury will ultimately be able to reach that conclusion. I don't know. That's a lot of steps in the future. All I'm saying is at this particular stage, we don't have enough information. We don't even have the accusation from Nike that's responsive to the shoe. All Nike said is, here's a bunch of comments we found. Without anything more. And then says, oh, it's evidence of actual confusion. How the hell are you drawing that conclusion, Nike? How the hell are you expecting me to draw that conclusion, Nike? You just want me to pull it out from the air? Maybe you want me to cast a spell on the ground and apparate it. You know, I could draw a symbol on the ground, maybe with some candles, and perform a ritual, and it could apparate out of the ground. Maybe that's where it's coming from, the apparition. But you're not doing a really good job telling me where you're getting this from, Nike. Thanks harder. Try harder. As noted above, MSCHF is deceiving consumers into believing the Nike manufacturer approves of the shoes. Literally none of those tweets or comments mentioned Satan's shoes, MSCHF shoes, Lil Nas shoes, or anything else that could positively identify those comments responding to the shoe. The closest we came in all the examples, which incidentally, one would think that this is the best examples Nike had, right? Because Nike could have quoted any tweets or any social media or anything, right? They could have put literally anything in this complaint, right? It's their complaint. So one would speculate that Nike, being a company that has the assets to hire good lawyers, scoured the net and found the best possible examples to put in their complaint to put the best foot forward. And literally all the examples suck. Not one of them expressly mentions MSCHF. Not one of them expressly mentions Lil Nas. Not one of them expressly mentions Satan's shoe. The closest we got is one tweet or whatever that mentions scripture being put on it, which I suppose maybe we can conclude that was the Satan shoe because of the scripture. But, you know, we have to deduce that. We don't know it for sure because they didn't even make it clear. And this was the best Nike had. These are the best examples of consumer confusion Nike could come up with all their resources and all their legal might. These are the best examples of consumer confusion Nike could dream up. You know, I think maybe their case is kind of crap. If this is the best they could do, MSCHF's customized Satan shoes, however, are not genuine Nike products. Nike did not manufacture or inspect the shoes. Nike did not authorize them to make, promote, advertise, market, or sell the shoes. While on information belief the shoes contain material derived from genuine products, MSCHF has customized them in such a manner they constitute a new unauthorized product. Okay. MSCHF has attempted to capitalize on Nike's valuable reputation and consumer goodwill by using the Nike asserted marks and or confusingly similar marks in a manner that's likely to cause consumers and potential consumers to believe the shoes are associated with Nike. Really, Nike? Really? You think that this will likely cause consumers and potential consumers confusion. And to support that premise, you have provided a whole bunch of tweets or other social media network comments, none of which mention MSCFF, Lil Nas, St shoes, none of which on their own terms expressly references the shoes, and the only one that kind of comes close is the one that mentions scripture being put on a shoe. So if you give them that one, you have one social media comment, one, that could possibly be read on its own terms, right? Not that you couldn't conclude it, not that you couldn't reach that conclusion, but on its own terms, there's only one, so we'll give you a half. You have half a tweet that on its own terms references the shoes in question. And you want to argue consumers are super, super confused. And you being very well paid lawyers, this is the best you could come up with, half a tweet. Wow. MSCHF has attempted to capitalize on its value reputation. By virtue of these acts, MSCHF has created a likelihood of injury to Nike's business will and goodwill, causes likelihood of confusion, mistake, and deception as the source of origin, and MSCHF shoes, and has otherwise competed unfairly by unlawfully trading on and using Nike's asserted marks. Unless stopped, the shoes and the use of the Nike asserted marks will continue to cause confusion, including but not limited to initial interest confusion, post-sale confusion. I want you to find someone with post-sale confusion. A person. Find me one person who post-sale believed that these are Nike authorized shoes. A person would be a good start. It's not exactly sufficient in any way, because again, we don't do lowest common denominator, but a person who post-sale is confused would be helpful. Confusion in secondary markets. This is the secondary market. And dilution by blurring and tarnishment. MSCHFs are willful and deliberate. Well, that much I don't think can be denied. MSCHF acts complained herein have caused damage to Nike in an amount to be determined. Sure they have. MSCF's act complained will cause irreparable injury. Count 1, trademark infringement. MSCHF has knowingly used and continues to use and market Nike's marks, like the swoosh. Constitutes infringement, is likely to confuse, mislead, or deceive consumers, right? That's kind of a key part of this thing. We look at this from a consumer protection standpoint. Likely to cause confusion, mislead, or deceive consumers. We're concerned about the consumers. We're concerned about the general public. We want to make sure they know what they're buying. Is the consumer confused? Not based on what you got. Is likely to believe in error that MSCHF St shoes have been authorized, sponsored, approved, or some way affiliated. Please show me consumer confusion. The examples you have so far suck. Try harder. Nike has no control over the nature and quality of the shoes. Yeah. Because the likelihood of confusion, which, is completely unsupported by your complaint so far. Any defects, objects, or faults will negatively reflect on our reputation. As direct and proximate result, Nike suffered and will suffer damage to its trademarks, business reputation, and goodwill that money cannot compensate. Money can't make us whole. Nike's further entitled to recover from MSCHF actual damages. MSCHF's use of the marks or confusing the slimmer marks has been intentional or willful. Well, you got that much. Bad faith evidenced by at least similarity of the marks and extensive nature of the infringement. Lame. Because of the willful wrong acts, they'd be awarded treble damages. Yeah, I suppose you can. You would get treble damages if you can get there. Yeah, you got the willful part. Sure, no problem. So yeah, if you can figure out how to make the rest work, sure, you can get treble damages. Unfortunately, for the moment, it looks like you're getting treble of nothing. So 3 times 0 is 0. So, entitled to recover costs of suits and attorney's fees because this is an exceptional case. All right. Yeah, we've mentioned this many, many times, right? In the American rule, every side pays for themselves. But of course, that can be modified by law. And this is an example where that is, right? So in the trademark statute, if it's an exceptional case, not just an ordinary case, but an exceptional case, you can also get attorney's fees. I'm not sure this is an exceptional case under any circumstance, but you might as well ask for it, I guess. False designation of origin. The marks are federally registered. Unauthorized use of marks. Deception of origin. Creating an affiliation with Nike. Nike suffered business reputation. Nike's furthering covered recover. Blah, 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 blah. Trademark dilution. As a result of this, the amount, volume, and geographic extent of Nike, their degree of recognition of the marks, they're famous. Yeah, the fact they're famous, I don't think anyone can dispute. Because Nike products bearing the mark have gained a reputation synonymous with fashion, quality, styling, authenticity, and sweatshops, Nike asserted marks have gained substantial renown. MSCHF has used and continues to use in commerce the Nike marks. Yeah, this if it's going to go anywhere, it's coming down to the swoosh. If this is going to go anywhere, it's coming down to the swoosh. Depends how much the judge cares that day. MSCF's use of the marks or consuming similar marks causes actual confusion. Please show me that. As a direct result, you suffer harm. They want to recover. Blah, 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 blah. Common law, trademark infringement, and unfair competition. They become widely known. Nike has products that become famous, have a reputation for quality, continues to advertise the products using the marks. Without limitation, they manufacture, promote, offer for sale the goods. As a direct result, Nike is sad, and it's bad faith, and we want a jury demand, and we want a whole bunch of things. We want them to be held willfully. They infringe the mark, use false designation of origin, diluted the mark, and violate common law rights. A judgment ordering everyone to prevent them from manufacturing, transporting, promoting, advertising, publishing, or doing basically anything else with the shoe, anything with the shoe, implying endorsement of the shoe, engaging in any act which is likely to dilute the quality, representing or implying, blah, 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 knowing its listing. We basically want them to stop in order that Nike is the exclusive marks of the marks and such marks are valid and protectable. Well, you can have that. I mean, you're already there. Sure. You can have a order that Nike is the exclusive owners of the mark and the marks are valuable and protectable. Sure. Great. Yeah, you can have that. I'm just not sure it's going to do you any good. In order that they be required to destroy all the products, in order granting damages, in order to give them any profits, which would be reasonable if they had damages, which they don't. In order 3 times damages, no. Award statutory damages, award granting punitive damages, or granting prejudgment, award granting, and such blah, 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 other stuff. Great. All right. So yeah, as you might have been able to deduce from my explanation here, I am not super duper impressed with this lawsuit. So this is all coming down to the use of the swoosh. Yeah, right? Because everything else is kind of crap. They have, you have the right to buy a Nike shoe. You have the right to modify the Nike shoe. You have a right to resell your modified product. This, incidentally, is not only true for shoes, it's true for literally all the products ever. So, if you buy a car, you can modify the car and you can resell the car, as people do. You can buy clothes and alter the clothes and resell the clothes, as people do. You can, insert X, modify them, resell, right? So the only thing you can't do is to confuse the consumer as to what they're buying, right? The consumer has to be aware of their buying, whether that's Nike selling or you selling, right? The same law applies to us all. So you can't buy a product, modify it, and then like try to pretend there's no modifications. So if you modified a car and then you say all factory parts or something, and that's not true, right? That's fraud. That's fraud. Can't do that. Yeah, you have to say, like, you don't have to make it particularly clear. You just can't represent that it's intact if it's not, right? So if there's been alterations and there's not obvious, you might have a duty to disclose them, but you certainly for sure can't confuse the consumer. The consumer, whether that's the first buyer or any subsequent buyer, has to be able to know what they're buying. That's part of fundamental fairness in trade, right? You have to be able to know what you're buying. We have to know what they're selling. Everyone has to be clear on the deal. This is basic contract law 101, good faith and fair dealing. So that applies to Nike and everyone else. So the only real question here is, and for the judge, is how much do I care about the fact that there's a swoosh on the side of this thing? How much do I care? How sophisticated is the consumer in this market? How likely is the consumer to be deceived? What is the evidence of confusion? Given what we have so far, kind of sucks balls. So forth and so on, right? So based on Nike's complaint, I don't think it's great. I mean, there's nothing wrong with how it's written, right? It's written well. It's just crap. Because the tweets or social media things they found, and this is presumably the worst examples they could dream up. Not doing that much for me. So I could see this going a whole lot of ways. I could see this getting moved. A motion to dismiss, right? A motion to dismiss 12b-6 is coming down the pipe rapidly. Yeah, coming down the pipe rapidly. And then how does the judge look at that? I don't know. Depends a lot on a lot of factors. Depends how familiar the judge is with trademark law. Depends how much the judge wants there to be some initial discovery, right? So I could definitely see this surviving a motion to dismiss, or allowing some sort of preliminary discovery to decide the motion to dismiss. So those are possible things. The judge either denies the motion to dismiss right now, maybe considers it later in a motion to summary judgment, or maybe the judge orders some limited discovery in order to decide the motion to dismiss. So takes it under advisement, waits for some limited discovery, try to find some examples of actual confusion or stuff like that. But, I don't, for example, really see a preliminary injunction or a TRO. And also, Nike didn't ask for it. They didn't ask for a TRO or a preliminary injunction unless they filed some other motion somewhere. So, yeah, I don't know. It wouldn't surprise me if it gets dismissed very quickly. It wouldn't surprise me if it goes to some limited discovery. It wouldn't surprise me if the motion dismiss is denied in favor of some discovery and then gets dismissed on a summary judgment. But based on what I can see right now, I don't see this surviving some eventual motion to dismiss / motion for summary judgment. Whether that will be next week or whether that will be some part down the road, based on what I can see right now, I don't see this surviving a motion to dismiss / motion for summary judgment. Unless, of course, we discover something in some discovery, if that occurs, right? So if we discover something in some sort of discovery that changes the calculus in some way, then maybe, but based on what we can tell right now, that doesn't seem particularly likely. So I think Lil Nas and whatever they are, Mischief, or whatever their freaking name is over here, have the better end of the deal. So, yeah, that's kind of where I see things right now. So were there any questions? Human blood is more edgy and thus the way to go. Maybe. That was from Wim. Hannah Burt says, yes, it's Science St. Peter. Also, I think MSC chef goes by Mischief. Thank you. Jeffrey Dunn says, is it possible this case is crap on purpose not to win, but solely to create more separation from the shoe and the Nike brand without harming secondary market? It's possible, but I don't know it's particularly great at accomplishing that objective. I mean, Nike has... It's coming down to the swoosh. I don't really see it going anywhere in the end. And because I think... The reason, by the way, and I sort of allude to this, is because I think that the consumer in this particular market is not likely to be deceived. We always have to consider the consumer of the relevant market. So what does the relevant market look like for these shoes? is a consumer likely to be deceived who's not a complete idiot? Like, I'll give you an example of something where this would work very easily and something where it wouldn't. So this is going back to an example that Lauren French and I talked about way back in the day when we were talking about Happy Time Murders, the movie, and we did a whole thing on that. And I said, yeah, this is going to be dismissed rapidly. And the chat at the time, and this is going back, I don't know, 3 years or something, the chat at the time's like, no, they have a really good complaint. The lawsuit didn't last the week. The entire lawsuit was over inside a week. So, it's like, yep, this isn't going to go anywhere. Chat's like, no. Sesame Street's right. This is going to prevail. Less than a week later, over. So yeah, this is going back to an example from them. So it would be an example where consumer confusion would be more understandable is you selling a soft drink, and it's going to be in stores, and your soft drink is red with white wavy lines, and has a scripted font, and so forth and so on. And so you take the can off the shelf thinking it's Coca-Cola because of those visible identifiers, and it's not Coca-Cola. Right, some other product. If you had looked at it a little bit more carefully, you would be able to see. But on surface glance, when your so we have to consider the consumer. What is the consumer? What does their behavior look like? So the consumer, the consumer's going into the store, is pulling something really quick off the shelf because they're driving or something, and they only later find that, oh no, the scripted wasn't Coca-Cola, it was some other brand name. The red was slightly different shade or blah blah blah. But that would be an example, right? What is the consumer likely to do relative to the good, relative to the market for the good? What level of inquiry, what level of sophistication is there in the relevant market? So I'm thinking it doesn't go anywhere because I'm thinking when you spend when you're spending $1,000 plus on some blood shoes, that maybe the relevant market would be not likely to believe they're authentic Nike. So that's why I don't think it really goes anywhere. Elidian says, does it matter at all that Nike didn't complain about the previous Jesus shoes? No, not really. Nike, no. I don't know enough about that to have an opinion. No, it doesn't really matter. Nike is in control of its mark and can raise complaints or not as it pleases. And the only thing Nike has to be concerned about is if it lets enough things go by that their mark could really become diluted. So there is some endpoint in the end of the rainbow where the mark becomes so diluted that it doesn't mean anything anymore. But whatever that mark is, we're a long way from that. And I don't think the Satan or the Jesus shoes are going to do that. So I don't think that's a real worry. Is law regarding digital products the same? Yeah, sure. When it comes to trademark law, yeah. When it comes to trademark law, sure. So if your question is the trademarks, yeah. The whole question of consumer confusion. So if something looks like an EA product and it's not EA or whatever, insert your hypothetical here, whatever the brand names are, yeah, it would be exactly the same. It would be, did you buy the product thinking it was something else because of the trademarks of the name? Were they the same or confusingly similar to another trademark? Yeah, it would be the same analysis, sure. Yeah. Who started the lawsuit? Nike did. Nike raised the initial complaint. Nike raised this lawsuit. So let's see if there's anything else on this real quick before I end the stream. I think there might be an affidavit, which I didn't download. I'm trying to see if it makes any difference for the analysis. There's going to be a hearing on June 29th. Whoa. June 29th? Wow. Wow. So the judge has scheduled a initial conference on June 29th. I don't know what that means in terms of everything else. Oh, there's no affidavits or declarations in this. So yeah, there's nothing here to do that. But I don't know if there's a motion to dismiss, if that'll be dead, but they put it hearing for June 29th. Oof. So yeah. Any other questions before I sign off? Great show. You're welcome. Yeah. Where you get a problem is copyright, because you generally make a new copy with the digital instead of making changes to the original copy. Yeah, copyright's different than trademark, right? It's a different philosophy. Copyright protects the creative aspect of the thing, and trademark protects the name and brand recognition. So they are different. There can be overlap between the two, but they are not the same concept. The shoes will be sold and gone unless there's a temporary restraining order or something put in, which they didn't ask for. Everyone buy Brooks because they're so comfortable. I might look into it. I'm rocking these Doc Marten Oxfords right now that I really, really like. So I think that's all for now. I hope this was educational. I hope you enjoyed my analysis. So we'll see where the case goes. I'm following it on Court Listener. We'll see what new filings happen. We'll see if there's a motion to dismiss, which I imagine there will be. We'll see what the judge says in response to a motion to dismiss. But yeah, I could see a whole bunch of things happening at this point. If I had to guess, I'm thinking outright dismissal is probably less likely at this stage. Some sort of initial discovery seems a little bit more likely, but we'll see how it goes. So yeah. If you are enjoying this legal education content, please remember to hit like on the way out. It helps us very much. Have you subscribed already? No. If not, please hit subscribe. If you're doing it for 99 cents a month, you too can become an civilian. It's true. If you hit the join button, you too can become a member. Colonel Crown says, do you plan to cover the Chauvin trial? Yeah, if I can figure out a way to do it, because I don't know that there's a great way to summarize it, because it's an all-day thing. I don't know how to do it. I was thinking about maybe doing opening arguments today, but then I got consumed with this. So I don't know how to do it on a practical level, but if I can figure out how to cover the Chauvin trial, then I will, because I think it's very, very interesting, obviously. But at least for the moment, I'm out, my friends. Hope all is well. Cheers and goodbye.